Like Patrice said, I'm an elder law attorney. I specialize in elder law, typical estate planning, special needs planning, and probate work. So today we're going to talk about, estate planning 101. There's a lot of misconceptions about what estate planning is, and hopefully we can clear up those questions today. And Janelle, the care coordinator, she's going to jump in here and there to talk about, ways to manage family members, elderly, maybe even disabled clients that might use estate planning to help themselves and to help the family as a whole. So let's get started. So an overview of estate planning, let's define what an estate is. So what people think of an estate, I hear many definitions about what an estate is. Some people just think it's a house. Some people just think it's real property that they own. Well, no, an estate is the sum of the total assets that one owns. Estate planning, though, involves decisions about who will manage the assets while that person's alive and who will inherit those assets at death. So estate planning, it involves powers of attorney while that person's alive and other documents while that person's alive to help them if something happens to them. And it also includes wills and trusts at death. So then once decisions are made, legal documents are prepared, hopefully by an attorney. You can gather these documents online, but you won't have the expertise of an attorney to help guide you preparing those documents, asking the right questions so you can prepare those documents appropriately. So the big step when preparing estate planning documents is having conversations with family. The documents themselves, they're sterile, they're boring. They have legalese in it. They may not make sense to a layperson, but what my job is to gather your thoughts, gather what you want, and you having conversations with your family to, put together those thoughts, and then I would put them together in a document, and we would go over those documents to make you understand it, and so we can parse through the legalese of everything. So what conversations with family encompasses, it makes you have a letter of intent, whether an actual letter of intent or maybe just like your notes put together, actual conversations that bring out, the emotions of what you're trying to do. And, then we put together an estate plan and put together those documents.
The conversations are really the most important part. And I think being open and honest with your loved ones, having that conversation and saying to them, nobody enjoys necessarily starting that conversation, but it's such an important one to have. And like Ethan mentioned, it kind of takes the boring out of it. It's a real life conversation. Where do you see things in the future? What are your wishes, both for your healthcare as well as like for your, actual physical estate? And I think the more often you have, maybe the first time you have it, you kind of touch on it. Second time you get a little more in depth. So the earlier you start having these conversations with your family, the better, for sure.
Yeah, and I think, having a conversation, for example, you creating a will or a power of attorney and you want to appoint your children as, the people that you want to be in charge. Well, maybe one child doesn't want to do that for whatever reason. They're uncomfortable or they just don't have enough time to do that. Well, having that conversation before you put together the document just makes sense. So that's why conversations is incredibly important. So I touched on a little bit what documents entail an estate plan. I don't know why this button is really jumpy, but the documents that the main documents that we prepare are the following: a durable general power of attorney. That's like a financial power of attorney, and we'll go into in depth these documents later. But I just wanted to touch on what the main documents are. A last will and testament, or just a will. Beneficiary designations on certain assets like retirement accounts, bank accounts, life insurance policies. Really, any financial account should have a beneficiary designation on it. Trusts, that's an important document that we use. And other documents that aren't important really legally, but they're important to clients, are the organ donation forms and disposition of bodily remains. So what happens to your body when you pass away? If you have certain thoughts on that, or religious thoughts on that, then these documents really help that decision-making process for your children, that you put that together, those ideas already through these documents. So a POA, or a power of attorney, in general, the POA is a document which you designate someone to be in charge if you are incapable. POAs can be effective, and most POAs are effective the moment you sign it, but they can be effective to spring to life upon a defined future event, such as incapacity. Really, I mean, I would say 99% of powers of attorney nowadays are called durable general power of attorneys, meaning they're effective the moment you sign it. And the reason for that is, it's hard to, if something happens to you, it's hard to get a doctor to put together an opinion that you are incapable of making financial or healthcare decisions in a timely manner. So the POA isn't effective until that doctor or doctors make that decision. So most POAs nowadays are durable general, effective the moment you sign the document. Healthcare decisions. One of the documents that we use for healthcare decisions is a healthcare power of attorney. The surrogate may make healthcare decisions anytime the attending physician determines the principal, you who have signed the document, has lost capacity to make informed healthcare decisions. So let's take an example. You go to the hospital, you're talking to your doctor. The doctor is asking you questions about your health, and he says, well, I recommend this procedure. You are a completely competent person making informed healthcare decisions. The doctor will not go to your power of attorney to ask them what they should do. They're going to ask you. The healthcare power of attorney will be effective once you lose that capacity where the doctor cannot ask you for that decision. Authority and types of decisions should be described in the agreement itself. They're as broad or as specific as you want, but healthcare powers of attorney should be able to make healthcare decisions for you when you are unable to make them, and have treatment and placement decisions in case that you're unable to make those decisions as well. A living will, which is totally separate from a healthcare power of attorney, applies when you're unable to make informed medical decisions and you are in a terminal condition or a permanently unconscious state. So these definitions are defined in the document. It's defined in Ohio law what a terminal condition or permanent unconscious state. Basically, that's when the doctor decides, or the document actually says that two doctors decide that, you know, there's no coming back from your condition. You are in a brain dead condition where a ventilator and feeding tube is the only way of you coming out of or staying alive. And at that point in time, a living will states, well, at that point in time, I just want comfort care. I want on hospice, I want to go peacefully. Documents wishes regarding withdrawal of this life-sustaining treatment. That's what the living will states. Janelle, do you have anything to add to that?
Sure. So the living will really is sort of the guide for what you want in your healthcare, and it does specifically talk about if you want a feeding tube, if two or more doctors say that wouldn't benefit you, would you want it? Would you not want it? It really is the guide for your power of attorney on healthcare. And as Ethan mentioned, it does talk about whether you want to be resuscitated or not. But in the state of Ohio, you have to have a separate form in addition to the living will, and this should be done with your doctor, whoever your primary care is, or whichever doctor you see, is what's called a do not resuscitate form. So the DNRs are really important, and I think people think when they do a living will that that's all they need. But in Ohio, especially, I can't talk about other states, but you definitely need a DNR designation. If you don't have one of these on your file with your doctor, your hospital, you are considered what's called a full code. So that means your heart stops, you stop breathing, you fall to the ground. They're going to do everything they can to resuscitate you. Now, some people have different diagnoses, maybe cancer or something more like long-term or terminal, and they might say at that point that they, do not want to be resuscitated in certain circumstances. So you might want what's called a do not resuscitate comfort care, a rest. And so that means, if your heart stops or you stop breathing, you don't want to be resuscitated, but you want to do everything up until that point. The important part about all this is talking to your doctor. So there's a lot of gray areas. There's a lot of areas in between. So talking to your doctor is so important, taking that time. And then it's talking to your family. I think that's the other thing. Some people put a DNR on file and they never tell their power of attorney for healthcare. They don't tell their children, they don't tell their spouse what their wishes are. And then it's kind of a shock. So I think being open and honest and saying, I don't want this, or I do want this, is really key. It always goes back to the conversations, but having that form is great, but telling your family why you have it and that it's in place is the most important part.
I want to make it clear that, the attorney's office, they can't prepare the DNR. That's only done at the hospital or at the doctor's office, and it's signed by a doctor with your signature, of course, too. So the attorney prepares the healthcare power of attorney, the living will, and you at the doctor's office or at the hospital prepares the DNR.
And really fast, all of these, I think I saw something pop up, but your power of attorney for healthcare, your living will, and a DNR should all be on file. I know, everybody uses like MyChart through Cleveland Clinic or UH. Any of those, even Metro, like you should talk to your doctor at your next visit and say, hey, I have these forms. I want to make sure they're in my medical file. And that way they have them at all times. So no matter where you go, whether if you did go to the ER, they can easily look it up and see where your forms are. For a long time, people would carry them in their purses or pull them out of the safe when they had to go to the ER or whatever. But it's a good idea just to have them there and upload it into your file so they're just taken care of.
Hey, Janelle, on that point, the question in the chat box, since we're talking about it,
Yep.
Julie had asked, she has hers on file at the Cleveland City Hall. And do you think the doctors ever access that system, or is the My Chart thing the better route to go?
The My Chart is a much better route to go. I can't say they do or they don't. I know that, unfortunately, I think when it comes to medical care right now, putting everything in front of them is the easiest way to get it done. So I don't think they'll ever go looking for it. It's much better to make sure it's in your file, like through My Chart or one of those.
So another, important tool that we incorporate in our documents are, for healthcare decisions is about mental health. There's a declaration for mental health treatment. That way you are clear in your documents that you want your agent to account for any mental health illnesses that you might encounter, whether that be psychiatric or dementia, Alzheimer's. That allows that person to appoint that agent and, preferences what medical treatment that you would want. So this is an important and useful tool that we use, especially for family members that might develop this because the other family members have a mental illness, or they have a mental illness now. This is an important tool to use.
And just a quick note on that, that it really, how I present it to individuals is when they are like medicated and they're feeling comfortable making these decisions, it helps keep them in control when maybe there's a point where medication isn't as effective or they've stopped taking their medications. It's keeping them in control of the decision making during those times when they really can't. And I think it helps to make them feel like they're still in control of their own care, even at a time where maybe they're not quite as able to be reasoned with. And I think it is a really good tool just to make people feel like they still have control over their, especially their mental health care. And it can be updated often. It can change over time. And it really does specifically talk about medications and different treatments that you would or would not be open to going through. So.
All right. So the big document that, most people have heard of is, the last will and testament, or just the will. So the bare bones definition of what a will is, it's a written instrument witnessed by two people that describes who gets what after death and nominates someone called an executor to take charge. All right, that's the basic definition of what a will is. So the executor manages the assets, collects them, liquidates assets accordingly, pays off debts, and distributes the remainder, the net of the estate, as the will directs, to the beneficiaries. And then the executor's discharge of their duties is supervised by the probate court, and this is called the probate process. So in probate court, you file an application with the will and the death certificate, and then after a certain period of time, the executor files an inventory to the court, showing the court, this is what this person, I believe, owns. And you can always update that if you find more items. And then the executor files an accounting to the court, showing I paid these expenses and debts, and I distributed this money to these people according to the will. The court supervises all of that and makes sure that the executor is doing a good job, and making sure that the executor is doing exactly how the will is prepared. But as you probably know, most people want to avoid probate. Why do people want to avoid probate? Well, it's time consuming. An estate in probate court could take over a year sometimes. it's public record. Everyone can see your business, and the cost is a lot more by paying attorney fees, court costs, than what you can do to avoid probate court. So avoiding probate court is also for a guardianship. You avoid probate court through a guardianship by accomplishing a power of attorney. So you can avoid probate court before death and after death by having the appropriate documents in place. The easiest way to avoid probate court is through beneficiary designations. You do not need a trust to avoid probate court, but as I'll talk in a little bit, a trust is a useful tool to avoid probate court. If you have a beneficiary designation on your accounts, those accounts will, at your death, will go straight to that beneficiary outside of probate court. So life insurance policies, annuities, retirement funds, bank accounts, automobiles, and real estate can all be transferred outside of probate court by putting a beneficiary on those accounts or assets. The beneficiary designation trumps what the will says about that particular asset. So if you say in your will that I want my real property to go to Sally, but you put a beneficiary designation through a transfer on death designation affidavit, and you say that you want that property to go to Bob, Bob will get that property at death because that affidavit trumps what the will says through probate court. So one way to avoid probate court, other than through beneficiary designation, is the use of trusts. So a trust, here's a basic definition. A trust is a legal vehicle where one or more individuals, called the settlor or the grantor, entrust some or all of their assets to a person or institution, and that person's called a trustee. The trustee agrees to hold, manage, and disperse those assets according to a set of instructions through the trust agreement for the benefit of the beneficiary. So the trust agreement is designed to meet one or more specific goals. Examples of these are, property management during the settlor's lifetime, as a probate avoiding mechanism, because the items in the trust will avoid probate court and trump the will, and hold assets for the benefit of a minor, disabled, or spendthrift beneficiary. So why would someone use a trust when they can just put beneficiary designations on their accounts? Well, a trust gives that person a lot more flexibility. So, for example, if you put your children down as a beneficiary, then the assets will go straight to that beneficiary. If one of your children would pass away, well, that child will not receive that share, and his children's, your grandchildren will not receive that share. It will go to the other beneficiaries. On most accounts, use that mechanism. If you had the assets going to a trust, the trust will give you more flexibility of where those assets will go if the beneficiary would predecease you. Also, if you don't think that a child is good at handling money, or that child is disabled, or something's going on with that child, like a divorce, bankruptcy, having it go to a trust will further protect that money for your family. So a trust gives you a lot more flexibility, a lot more control, but you can avoid probate not using a trust. Sometimes I say to a client, you don't need to use a trust. That's a waste of money. You can just use a beneficiary designation. But a lot of clients say, no, I like the flexibility. I like having a little more guidance for my children, especially if they have minor disabled or, a child that's going through some issues at the time. So, Janelle, you want to take this one? You're on mute, Janelle.
Sorry. A lot of this goes back to what we already talked about as far as conversations, but when you're starting to think about all of this, even if it's about your financial estate, you really need to start thinking about assessing your care needs. I think that's so important, especially as we're getting older and things change with our healthcare. And I think,
and this also goes in the line of what your parents are doing right now too.
Sure.
Not just you, but your parents.
Correct. And seeing, start thinking about, especially when you're looking at, loved ones, your aunts, your uncles, your parents, looking at, is 24-hour care a necessity? Is it going to be in the future? Is there things that they're not able to do, as far as like, do you know 911 in an emergency? The most common thing I hear is someone goes, I know what to do in an emergency. I'd call my son or daughter. Well, that's great. But in an emergency like a fire, it's really important that people know who to call, for response time and how to get out and having a plan. So I always stress to people, when you're looking at someone's living arrangements, if there was a situation that came up, would they know how to handle it? Is there a certain diagnosis that might make, this decision making questionable? So, just getting a dementia diagnosis does not mean that you suddenly need to have 24/7 care. But it is something to think about for the future, as needs change. Is there a pattern of behavior that makes, things unsafe or risky? Leaving the stove on, could it start a fire that maybe they're unaware of? Is someone wandering? Are they just walking out the door and then kind of getting confused, not sure? So these are things you're looking for. I always caution everyone, because I think people go, oh, they have dementia. That's not good enough. Like, there really has to be more to it. And sometimes, people do get a dementia diagnosis very early on, and maybe it affects something different, like their speech. That doesn't mean that they can't remember who someone is or where they're going or what they're doing. So tread lightly with that one, for sure. You're also looking at their physical needs. So going back to the safety piece, some of these older homes, people are, there's only an upstairs bedroom or bathroom, and maybe people can't do stairs anymore. So it's always looking at, like, are their physical needs going to be met in the home that they're in? Do we need to start looking at possibly getting a different home that's all one level, a ranch or something to that effect? So it's all these things you have to kind of look for. And also, I think it's important, after this past year, I know a lot of people have had a lot of, anxiety and feeling isolated, especially some of our older people who stayed away from family because they were afraid of COVID, or their family didn't want, to expose them to it. Can their social and emotional needs be met at home? Should they, should we consider a more like an assisted living, or even an independent living that's in a senior complex, where there's more social interaction, there's more things for them to do as opposed to sitting at home alone? So all of these, really, you need to look at all of this. We always stress looking at the least restrictive option. And by that, I mean, are there things we can put in the home that would solve some of these problems? If that's not the case, what's the next living alternative? Without, we are never the people that want to go in and be like, okay, we just have to place you in a nursing home. It's not like that. Like I've mentioned before, there's tons of steps in between, and there's a lot of things to look at. So I think during this estate planning process, looking at your care needs, what does the future hold, is so important. And being honest and saying, gosh, maybe in another 5 years, my house setup is not going to be appropriate for my needs. And I think starting that conversation and then planning ahead and putting it in, the documents is really important. We were sort of talking about some of the senior living options. I mentioned it's always like I'm at home or I'm in a nursing home, but there are a lot of options out there. There are these senior apartment complexes that are available for people 50, usually it's 55 and over, some of them are 65 and over. And they do have like a care manager, or maybe they have a congregate meal once a day or options for meals. So some of those are kind of nice. There's a little more socialization rather than just living in your home alone. There are in-home care options. We're lucky in our area. There is a PACE program, which provides, it's a program of all-inclusive care for the elderly that provides some in-home care. There's Passport, there's home care agencies. And depending on where you live, sometimes if you're a little further out, it is a lot harder to get in-home care, but that's something that we need to talk about and discuss on, what is the reality of that. Then there's a lot of what's called like continuing care communities. A lot of those start with sort of an independent living. Maybe it's a townhome or a condo setup where a couple or an individual can move to. They're still independent, they still drive, but they're still connected to the continuing care community. And then as their needs change and evolve, maybe they have a fall and they need to go to the skilled nursing facility, get some skilled rehab and move back to the independent living. Or maybe they need a little more care, a little more assistance. And that's when you're looking at an assisted living. And that's exactly what it sounds like. They assist you. So it's not full 24/7 provided care, but maybe you just need someone to remind you to take your meds every day. Or maybe you just need some meals. Some people like assisted livings because, again, they're lonely and they want to be around other people. So they have their own apartment in an assisted living, and then they can go out and have meals with others, which can be really great. Then obviously there's skilled nursing. I think people panic when they hear they're going to have a surgery and they're going to need to go to a facility for skilled rehab. That's not always permanent. A lot of times that's for a short period of time to get that 24/7 skilled care. And it's also good for your medications as well. And then there's sort of that long-term care aspect that I know a lot of people aren't fans of, but there are nursing home facilities that do provide that long-term care. And they oftentimes will work with families. They can be expensive, but part of what we do is try to help with Medicaid planning ahead of time or when that is a need. And then sort of the other option that a lot of people forget about are group homes. I think group homes sort of have a stigma to them, but a lot of group homes are like 5 to 7 people. Usually someone will buy a home and they become a group home operator and they allow, a small number of people to come in and live in their home with them. They provide meals, they make sure their medications are reminded to be taken. And they have flexibility, they can kind of come and go, but it's a nice option for people. Some people do stay in group homes that have mental illness. Some people stay in group homes that are designed for those with developmental disabilities, but there are also group homes out there for seniors, people who are just feeling a little lonely and need a little more supervision. And so those are a great option as well. I think the key with any of those, and this is the hardest part, and I think this is really stressful right now for people that have loved ones in facilities, is communication and transparency. So I think it's really important when you're having these conversations with your loved ones, you're thinking ahead, you're assessing your needs, is to be honest about what you can and can't do for yourself. If your loved one is in a facility or if you end up in a facility, having one person be the emergency contact, be the main spokesperson. I've had families that have 12 kids and all 12 kids are calling the facility at different times trying to get information. That's very overwhelming. And they, unfortunately, especially right now, getting over COVID and dealing with all the different policies that have popped up. Sometimes you can visit, sometimes you can't, that type of thing. They really can't focus on talking to all these individuals. So having one point person, and it might not be you. My grandma was in a facility, and this is even years ago, and she said, all communication goes through my granddaughter because it's just too much for me. So they would talk to me and then I would, talk to her, but it would just made life a lot easier on her to not have to hear it all from them. So And that's fine. I just think making that one person be the point person. It's also important to remember if they're in a facility, you can always request a care conference. And what that's designed to do is to sit down and sort of say, here's maybe what I'm concerned about or I have questions about. And for them to come back and say, well, this is what we're providing, this is what we're seeing. Because sometimes it can be different. Sometimes what our loved ones tell us is happening might not necessarily be happening, or that's their perception. So it's a really good idea to get on the same page as the team. And then I think really staying focused. So sometimes it's hard. Sometimes we see a loved one in a facility and their shirt's dirty and we're kind of upset about it. But I think focusing on very important care needs, your care questions, and then kind of following up and saying, hey, they've always, that we're worried about their dignity and we want to make sure that, they're getting changed regularly and things like that aren't happening, and expressing them. But staying focused, I tell people, make a list of your questions, your concerns. Sometimes sending it to the staff ahead of time is a great idea, so they have a response prepared, because a lot of times the care conferences aren't very long. And I think the biggest key to any of this is patience. We need patience with our loved ones when we start these conversations, and maybe they're not willing to talk about it at the time and you have to go back and regroup. I think patience with the staff at these facilities, because unfortunately with COVID, there have been some staffing shortages and home care shortages, and just being patient. And I think that's the most important part about planning ahead, is because right now in a crisis, it's really hard to put things in place. So the more you talk about it ahead of time, the better off it'll be.
So on the point of, incompetency, if you do not have a power of attorney set in place, either, you forgot about it, or you don't trust that person for whatever reason. The only other option for your loved ones than to make decisions if you become incompetent, either through mental impairment or disease, is through a guardianship. And that's the last place that anyone wants to be, because of the cost involved with guardianship, and just the overall headache of guardianship with probate court, where if that person would have just signed a power of attorney and had the correct people in place as the agent of the power of attorney, could just avoid that entirely. But let's just go over incompetency real quick. Incompetency is a mental impairment caused by a mental or physical illness, a developmental disability, or chronic substance abuse. And it makes that person incapable of taking care of himself or his property and meeting legal obligations, financially, or their own health care, their own health decisions. So like I said, the only option for someone to take care of their health, or having someone else take care of their health and finances, is either through a power of attorney that person signs, or if they don't sign a power of attorney, a guardianship. And a guardianship is the loss of your legal rights to make decisions of your own. The person applies to be guardian through probate court, and that person will be in total control of finances and healthcare decisions with probate court supervision. So the guardianship has two aspects of person and estate. It's really the last place that anyone wants to be. And simply just signing a power of attorney while that person has capacity creates, ease of use for that loved one and for that person that's suffering from whatever illness or disease that they have in the long run. So that's my final spiel about, having that conversation with loved ones, with family members, friends about a power of attorney will, is, I know it's uncomfortable at times, but getting that taken care of while you have that capacity, you're far better off doing that than having that loved one eventually getting a guardianship over you when it's too late. So I think that's all we have. I know that there's some questions that we're going to get into. Janelle, did you have any final points that you wanted to make?
No, I hope this was helpful. I mean, really, like I mentioned multiple times, is having that conversation often, frequently. It can change over time. And even the documents themselves can be changed and updated, language changes and, laws change, especially in regards to like Medicaid planning and even in the trusts and the powers of attorney, they've changed the wording over the years and they've added things. So updating your documents is also just as important. So if you have a document from maybe 25 years ago, it's great that you already have that in place, but you should also look at updating it just to make sure that it's as up to date as possible.